We will go on the record in the matters 24 CF 170, 24 CT 33. State of Wisconsin versus Jacob Jones. The state appears through Assistant District Attorney Holly Rockow in person. We have Mr. Jones in person in custody with counsel Gabriel Pollock. We're set here today in these matters for two things. First is with regards to 24 CT 33. The OWI third was inadvertently dismissed and read in with the agreement, and I do not believe that was part of the agreement. Is that correct, Mr. Pollock?
Your Honor, I guess I'd spoken to Ms. Rockow earlier this morning, and we had just noted that it had been read in and believed we were here for sentencing in the 24 CF 170 matter.
No.
Understood, Your Honor. I can certainly conference with Ms. Rockow to see how she would like to proceed with that. I guess I'm not sure how the court would prefer to proceed.
Because the OWI third was not a part of the agreement to be dismissed and read in particular because the legislature, as well as the public and the public interest, looks at those matters, the OWIs, very, very seriously. And that was overlooked by all parties, including the court, when all the multiple cases and multiple things were put on during the plea hearing. So with regards to 24 CT 33, that matter, the court does not allow that matter to be dismissed and read in. And if that affects today and what's going to happen today, then we need to address that, and this matter needs to be reset because, again, the OWI third in 24 CT 33 was not a part of the agreement that was reached between the parties. And that was not the agreement that was recited to the court. If that was recited to the court would not have permitted the agreement and would have proceeded to trial.
Understood, Your Honor. I believe that Ms. Rockow and I can likely come to an arrangement. I just had not done that at the moment, but I think we can likely have that figured out.
All right, so why don't you go conference with Ms. Rockow, and then you're going to need to conference with Mr. Jones because I don't want him to feel rushed, but this matter can all be reset to a different date and time. However, I do understand that this is your last day on the public defender's office in this capacity, and another public defender would need to be retained or appointed.
Yes, Your Honor, I appreciate that. I also know that there are numerous people here in support of Mr. Jones, so if we can accommodate this, that would be my preference.
All right, we will briefly adjourn. Back on the record, same appearances as previously noted. The parties have reached an agreement. Mr. Pollock has went over a plea questionnaire waiver of rights form as it relates to 24 CT 33, operating a motor vehicle while intoxicated. Mr. Pollock, can you please recite the agreement on the record after the court is making the formal order to reopen 24 CT 33, because that was not a part of the original, that was not a part of the agreement, correct, Ms. Rockow? Correct. And correct, Mr. Pollock?
Yes, Your Honor.
All right, please recite the agreement for the record.
Your Honor, our understanding of the agreement, if Mr. Jones enters.
So slowly.
Yes, Your Honor. Our understanding of the agreement is if Mr. Jones enters a plea of guilty to count 1 in 24 CT 33, which I believe is the operating while under the influence of an intoxicant, count 2 and 3 would be dismissed count 3 would be dismissed and read in, count 2 would be dismissed by operation of law, or nope, count 2 is not operating while revoked. I thought there was a prohibited alcohol concentration. So the remaining counts would be dismissed and read in, 1 as a matter of law. The parties would join in recommending a sentence of 45 days in the county jail, a fine including the various surcharges of $1,844, loss of operating privileges, and requirement for an ignition interlock device for 24 months.
Where are you coming up with those things? You're just kind of pulling them out of the air?
Your Honor, I think a lot of this was the.
That's not even my IDIP guidelines, which is the lowest, and that's not even the district guidelines.
Your Honor, I guess
Your Honor, I think that we're now viewing these as, this is now kind of a global situation that we have here. We're resolving the felony file and the CT file together. The 45 days is the statutory minimum period. I think that's appropriate, given the recommendations the parties will be making for the felony. We are recommending a lengthy period of supervision. So I think that's appropriate, given that level of protection to the public. Also, I understand that Mr. Jones spent 12 months in the county jail, or was sentenced to 12 months in the county jail due to the revocation. So I think that we can also factor that in terms of what's best for the public. The other thing is that there was an IDIP recommendation or offer that was made, of course. He had begun doing that process, as I understand it, according to my file at least. And then of course he was incarcerated. We're coming up with the 45 days because that's the statutory minimum.
Okay, what about the 1844, the 1,844? That's just a random number.
That's the 10th district guidelines for this offense date from the 2023 grid.
But this occurred in July 2024. My July 2024 grid is 1869.
The OWI was February of 2024. I don't think that the guidelines had gone into effect at that point.
Right.
You're right. I was looking at the burglary.
Correct.
That is correct.
So the state has no objection to the minimum fine.
All right. Okay. Now we're making sense. All right. Okay. So that's the agreement that's been reached, Mr. Jones.
Yes, Your Honor.
Now we're going to move on to sentencing, and we will in fact do a dual sentencing in this matter. We have the sentencing for the operating while intoxicated third offense, and we do have the sentencing in the 24 CF 170 matter, in which you did plead guilty to 1 count of strangulation, suffocation, 1 count of false imprisonment, and 1 count of stalking. They are all felonies. The court ordered a pre-sentence investigation report. The court has reviewed that report thoroughly. Ms. Bauer, victim witness coordinator, are we going to have any victim impact statement?
No, Your Honor.
And in my review of the case, I did not find any impact statement filed in this case. Is that correct?
Yes, Your Honor.
The only information that I have received from the victim would be the information contained in, I believe, in the complaint.
Yes, Your Honor.
Okay, all right. Ms. Rockow, argument and sentencing recommendation, please.
Thank you, Your Honor. The state has considered the material in the PSI, and of course, all of the facts and evidence in this case very carefully, and is joining the defense in a recommendation to the court for an imposed but stayed prison sentence. Specifically, the state is recommending that Mr. Jones be sentenced to an imposed but stayed sentence of, as to count 3, 2 years of initial confinement, 2 years of extended supervision, as to count 6, imposed and stayed 2 years initial confinement, 2 years extended supervision, and as to count 7, imposed and stayed 1.5 years initial confinement, 2 years extended supervision, all to run concurrent to each other, as this was one incident. I think that it's appropriate that they do run concurrently. In reviewing Mr. Jones' history, he does not have a violent history. He has a history that looks like somebody who uses alcohol and makes bad choices when he uses alcohol. He is fairly young. And I think as evidenced by his criminal history and by what was outlined in the PSI and the facts of this case, he has a lot of rehabilitative needs. But the state disagrees that there is an obvious pattern of serious conduct that the defendant has engaged in, which was mentioned in the PSI. The only pattern that I see is that he has multiple OWI convictions. So that suggests a pattern of substance use. In considering probation first, I think that based on his record and based on his rehabilitative needs, the safest thing for the community is to indeed rehabilitate Mr. Jones within the community. I believe that probation can adequately supervise Mr. Jones within the community and do that in a way that will protect the community, that will protect the victim as well. He'll have to engage in day-to-day real life.
What about 22 CF 012? And now there is a material fact that I have just discovered because DOC put it as 22 CF 212. Yes, it was dismissed and read into other cases, but there is a very similar fact pattern that was charged out by the district attorney's office. Very, very similar, where we had there were allegations of strangulation, suffocation, battery, disorderly conduct. Perhaps that's where we're getting the pattern from the DOC agent.
And I agree with Your Honor. I think that that is the pattern that's the only pattern that they could be pointing to. My concern in using that as a basis for a pattern is that it was dismissed. It's a dismissed case. I don't know.
Then why was it charged by the district attorney's office? And we have the facts in that criminal complaint. Dismissed but read in charges. Are the courts able to view those and use those for sentencing purposes? Not only for restitution, for sentencing purposes. And for whatever reason, back when he pled out in those cases, that was the deal then. It can't be overlooked.
It can't be overlooked. I agree with that, Your Honor. And I wasn't in this office in 2022, so I don't know. But I can say that it's not my practice to dismiss a case that serious unless there were some issues with the case itself and issues with proving that case. I don't know the facts and circumstances surrounding the dismissal of that case, but it looks to me like it was dismissed in favor of bail jumps. And so
bail jumps look better on a criminal record for a criminal than does strangulation, suffocation, perhaps. That's why you wheel and deal.
Of course.
Doesn't mean the facts didn't happen. That's why you wheel and deal.
Right. And agreeing, to have something dismissed and read in also means that the state can't bring those charges again.
Except in another case like this.
So I don't know the particulars of that dismissal is what I'm saying, Your Honor, but the nature of how that case resolved with the felony bail jumps doesn't change my perspective in my sentencing recommendation. I want the court to know I did not overlook that case in making this recommendation.
You looked at the underlying facts in that case?
I did.
That it involved his previous girlfriend?
And Your Honor, what I can say is that, again, if this case weren't resolved in the manner that it was resolved.
Well, I'm going to say you don't know why it was resolved the way it was or how it was or what it is other than wheeling and dealing and what looks better on a criminal record.
But I don't believe that the state would take that lightly and those charges lightly. And
you can't say that because you weren't in those shoes.
Correct. Yes. I don't know.
All right, you may continue with your argument.
Regardless of that case, I believe that this is an appropriate recommendation. We still have to consider probation first, and we still have to consider the rehabilitative needs of the defendant, his character, not just the severity of the facts in this case. I think that, again, his record more than anything reflects an issue with substance use. I think that's outlined in the PSI. There are some mental health struggles that are outlined in the PSI. His familial background, I think, tells us something about maybe how he got to be where he is today. The bottom line, Your Honor, is I don't think that we're at a place with Mr. Jones at this moment where he needs to go to prison. Thank you.
Thank you, Mr. Pollock.
Thank you, Your Honor. I concur with the state. As Ms. Rocco stated, this is the at this point a joint proposal before the court. I think I'm going to start by asking the court to adopt our sentence in the OWI matter. I think it's 24 CT 33 first. 45 days is the mandatory minimum penalty that the court can impose and must impose in a case like this. Mr. Jones was coming into this hearing without knowing that the court expected a plea and sentencing in that case as well. And to his credit, he didn't balk at it. He went through the plea questionnaire. He entered the guilty plea and he accepted a jail sentence despite knowing that the parties came into today asking the court to essentially let him out of jail today. So I think that speaks to the place that he is in now and how far that he has come. It's always strange, Your Honor, to be talking about serious violent type felonies for a 24-year-old man. And it's not something that I think any of us in this room take lightly. As Ms. Rocco stated, he did plead guilty to those. And as Your Honor stated earlier, that's different than felony bail jumps. Like, these are not dismissed and read in. These are convictions of record that will stand. I know that Mr. Jones may have disputed some of the facts or provided statements to the PSI writer that maybe tried to make himself look a little better than he was that night. I know in another case, I spoke to Dr. Courtney Endress of a similar situation. It wasn't this case, but I mean, I think it's, to echo the doctor, it's something people do when they're confronted with things like this. They try and make it a little better for themselves. And I only bring that up because Mr. Jones has not backed away from this. He has remained in custody since, I believe, July 20th of 2024. He has not complained. He has taken his time and I think demonstrated an extraordinary growth. In our meetings, he's described a level of insight into his need for certainly AA and alcohol and other drug abuse assistance and treatment and programming.
But he says in the PSI, he doesn't believe he would benefit from additional treatment.
Your Honor, he may have said that. He has also confided in me that he has been doing Narcotics Anonymous and Alcoholics Anonymous while he's been in jail. I contacted Pastor Jack, who is the person who he told me was providing those services to him. Pastor Jack did provide confirmation of that to me, which I filed with the court this morning. Just reading briefly from that, I've met with Jacob weekly, and I've been involved with the jail AA and NA meetings on Monday and Thursday evenings at the Burnett County Jail. Mr. Jones engages during the meetings, and in one of my meetings, he seems to comprehend that the legal situation he finds himself in, what it's been grounded in, or the root cause of the behavior. So maybe he said that, maybe he even believed that at the time. And maybe he was only going to AA meetings for something to do or to try and make himself look better, but it sounds like he's engaging. Maybe he has had that breakthrough moment. I think he probably has. He confided in me this is the longest period of sobriety he's had since he began drinking. And I think that's very important, regardless of whether it was forced sobriety or not. It's been since July since he's been able to have any alcohol. He's also described his struggles with his mental health issues. I've gotten to know him and developed more of a picture of him. Had some very early issues with trust. There was a description in the letter provided by the individual Sasha Stavro, who is here in court today supporting Mr. Jones, that despite never being a legal stepfather, that he considered himself the person in that role. And I think it's described in the PSI. When that relationship fell apart, Mr. Jones had, I think, looked through a cell phone and found some messages that were very concerning to him. That's a behavior that apparently has continued. That's the sort of boundary that he needs to learn is not okay. And I think that's something, as Ms. Rockow stated, that can be addressed in the community. His issues of trust, alcohol abuse, and mental health, that's a lethal combination that he does need to address. I think that our agreement is appropriate, and it's very hard for me to even say these words, Your Honor, to ask to impose a prison sentence for a person who's 24 years old. That is what we are asking. We are asking you to impose a prison sentence that essentially turns into 2 years of initial confinement followed by 2 years of extended supervision. As Ms. Rockow stated, this was a single incident, so I think concurrent sentences are appropriate in that regard. That would be obviously consecutive to the OWI sentence. And then we're asking you to stay that for a period of 4 years of probation. I think that the extra year beyond the standard 3 years is appropriate given the multiple felony convictions. He does have a child, Your Honor. He will always have a child. That is something that he needs to address this before the child gets older, before these sort of behaviors can occur again.
And for the record, I know your argument was, and he didn't know about pleading to the OWI, but the recommendation is for the lowest guidelines, which if he has 36 days in jail, that would mean that he would have already sat his time with conditional jail. He would have 33 days.
I guess, Your Honor, if the court were to apply this,
If the court were to follow the recommendation, correct, but that would be. So that's just where we are with that. All right, Mr. Jones, argument or do you have any argument? Do you have any statements? Do you have anything that you want me to know about this case, about you? And it looks like you want to read something to the court. And if you're going to read something to the court, I'm going to say, read it very slowly, please.
Okay.
My court reporter needs to take everything down, and it's hard when people read fast.
Yes, Your Honor.
All right, you may begin.
Your Honor, I'd like to start by apologizing for my actions. There hasn't been a single day that I haven't thought about what I did. It's my biggest regret in life, and it haunts me. I would give anything to take it all back. I truly am so sorry. The last few years, I've been struggling with alcohol and my mental health. It caused me to lose sight of myself and my goals, and I've made a lot of bad choices. I've lost friends, family, relationships, my freedom, all because I let emotions and an addiction control me. I'm done living my life like that. I'm not that kind of person. I've never spent this much time in jail before, and these last 8 months has given me a lot of time to think and reflect on myself. I've gone to every AA meeting and every Bible study the jail offers, and I've learned a lot about my addiction, sobriety, and my faith. I was actually baptized by Pastor Jack here in jail on March 18th, and I started a new life giving it to Christ. I've been working really hard towards becoming the best version of myself, and I can honestly say that I am a completely different person than I was a year ago. With God and sobriety in my life, I'm the person I want to be, and I truly am in my heart. I have a new outlook on life, and it's too precious to spend in jail. I realized how many things I've taken for granted, and I don't want to miss out on any more of my life sitting in jail. It's not only my life that I'm missing out on either. My daughter Esme is 5 years old, and I missed her first day of pre-K, her first Christmas concert, and her birthday last year. Those are all big moments in her life that we'll never get back, and I miss them because I got myself put in jail. I miss her so much. She brings me more happiness than anything ever has. She's my motivation to turn my life around and to be the best that I can be so that I can be there for her and set a good example. I love her more than anything in this world, and she needs her dad. Her mom needs my help too. It's not fair that she's had to do everything on her own. My immediate plans when I'm released from jail, I've been offered an amazing opportunity by Pastor Jack to come to the Ruth House where I'll have help finding employment, housing, AA meetings, therapy, and getting my license back. I'll also be able to help them give back to the community, which is something I've been wanting to do for some time now. I understand that sometimes there can be complications with going to the Ruth House if you're on probation. So if there's a problem with that, I have another plan set in place. I can interstate compact my probation to Minnesota and stay with my family friend Jeremy while I save up money for my own apartment. I'd be going back to my old job at Wing Joint and set up a schedule to have Esme. I've reached out to a peer recovery specialist who said he would help me find a sponsor and bring me to AA meetings. Miranda, who works with Mr. Pollock, already found me a program in Minneapolis for therapy and domestic violence classes. I also plan to see a specialist at Abbott Hospital for some health issues I've been having that could be related to Crohn's disease. So I'm going to get tested for that as well. Some future goals I'd like to accomplish further down the road are to take classes for IT and get a job in that field. I'd also like to find an opportunity to talk to teenagers and young adults about the effects drugs and alcohol can have on your life and encourage them to stay sober and let God into their lives so they don't make the same mistakes that I did. Your Honor, I ask you to please not give me an immediate jail sentence, but probation with a withheld or state imposed sentence over my head. I promise you that I will meet all the requirements for probation, and when I complete it, I will write you a letter to tell you about how far I've come and my accomplishments. I'm ready to move forward with my life and show the world the new me. So, Your Honor, I ask you to please give me the second chance to go out and be successful and prove that I'm a good person. And also, Your Honor, I would like the court to take into consideration for my OWI that at the time of my arrest, for that OWI, I served 44 days in jail from February 18th to April 1st of that year. Thank you.
When a court sentences an individual, as Ms. Rockhow pointed out, I have certain factors and certain things I have to look at. First and foremost, the nature and the gravity of the offense. How serious are these crimes? Second, I have to look at your character, your past criminal record, and that would include all of the criminal offenses in your record, okay? I have to look at, third, needing to protect the public, all right? So I have to look at those three things first, and one can outweigh the other, or I can have two that are about the same, on the same scale. But those aren't the only factors that the court looks at in sentencing. I also do have to look at the effect of the victims, how your actions affected people, especially the victims. I have to look at your rehabilitative prospects. I have to look at this, as everybody's stated in here, is there a pattern, an undesirable behavior pattern in what you've been doing? I have to look at your culpability. I do look at your age, your education, your history. I also have to look at deterrence. There are two types of deterrence. Specific deterrence to specifically deter you from continuing to do these types of actions, because this isn't your first time in front of the court for very, very similar things. When I look at all of the crimes and what you were charged with and the maximum possible penalties, if you were to go to trial in both of those cases, and you were convicted on all of those charges, the maximum possible penalty you could receive on those convictions would be 63 years and some odd months. 63 years of prison hanging over your head. And that's not all in prison. Some of that is initial confinement with extended supervision. But we all know extended supervision means you could serve that in prison. But 63 years with these crimes that you've committed and that were a part of all of your actions on July 20th, 2024, and then on February 18th, 2024, 63 years. With the allegations of the burglary, the strangulation, suffocation, second-degree recklessly endangering safety, false imprisonment, stalking, criminal damage to a dwelling, or criminal trespass to a dwelling, and the OWI. So serious. They're all very, very serious. And I have a pre-sentence investigation report that is very voluminous in information. I like them. It gives me a lot of information. And then I have a joint recommendation from both the state and the defense. The Department of Corrections is saying, you know what, Judge, in our review, in our determination, in our looking at this thing as a whole, we believe that this is a prison sentence, and it's a prison sentence now. 2 years, 2 to 3 years in with 2 to 3 years out. And then I have a recommendation from the state and the defense, both saying, you know what, Judge? Yeah, he's young. We don't really see a pattern here. He can change. It was alcohol or substance driven. Let's look at his rehabilitative needs. Let's look at that. Let's weigh that at the highest instead of the severity of the crimes and protecting the community. See, I remember that 2022 case, and I remember when that happened, and I do remember that agreement. And it is. A lot of times the system is, it's just wheeling and dealing. What felony do you want on your record? What do you want on your record? I want this one, or do you want this one? Do you want this one, or do you want this one? DAs are usually happy with, I got a felony conviction. Yay, good for me. It's a felony. Because in 2022, pretty much the same conduct and behavior happened. Pretty much the same, except you didn't break into her house. They may have been dismissed and read in for your global agreement and deal that you got in 2022 for your felony bail convictions, but the same underlying conduct for why you're sitting here today. And that can't be overlooked. It just can't. This was a serious and violent attack. On July 20th, 2024, you had a plan. Whether or not you were under the influence of alcohol or other substances, you did what you did, and you had a plan. You went to the victim's residence. You broke in to her house. You startled her. She was in the bathroom showering. You punched her in the arms through the shower curtain. You grabbed her around the neck. You punched her in the chin. You squeezed her neck tightly. She reports losing consciousness. She regained consciousness. She tried to leave the bathroom. You pushed her. You grabbed her and forcefully shoved her head into the toilet, causing the toilet seat to break away from the toilet. You then grabbed her neck for a second time until she lost consciousness again. Upon regaining consciousness, she managed to make her way out of the bathroom. You continue to yell at her and demand that she go back into the bathroom to discuss some text messages that she had on her phone. This was over text messages she had on her phone. And I understand you may have underlying trauma with your mother cheating on Sasha and you being the one that looked at her phone and you found those text messages confirming, at least to you, that she was cheating on Sasha. It's got to hurt as a kid. It's got to hurt as a person who has a man in his life who has been there and been his rock. And I'm sure you were very angry, very hurt, very traumatized. And I'm sure that did stick with you. I'm going to guess Sasha didn't do this to your mom. But I don't know. Doesn't say here and here, and I don't have any arguments or anything that says that you witnessed Sasha beat up your mom. And then after, you continue. You don't just stop after this incident occurred. And after the victim gets away, you continue by sending her over 100 text messages and several calls, and you continue to do this. Thus the stalking. You just wouldn't leave her alone. You just couldn't leave her alone. And this is a pattern. This is very similar to the 2022 case with your ex-girlfriend. Very similar pattern. Fight, grabbed her neck, pressed hard, suffocation, close to losing consciousness, over jealousy. Again, whether you were intoxicated or not, and I believe, if I'm recalling correctly, there was like 8 beers, and I can't recall if it was this case that you said that you had 8 beers or the 22 case you said you had about 8 beers. But again, I get that you're indicating that you were intoxicated or that's your excuse. A lot of intoxicated people, even if they're being cheated on, don't become violent and strangle their partner to the point of unconsciousness twice. And I understand that you're a father, and I understand that you have a child, and that's sad too, because she is also a victim. She's a victim of your conduct and your behavior. She's a victim of your alcoholism. She's a victim of your choice to have other things come before her, because they have. Ms. Rockhow is very correct and very right in the fact that my higher courts tell me I need to first consider probation unless confinement is necessary to protect the public from further criminal activity from the defendant, or if the defendant needs correctional treatment, or if probation would unduly depreciate the seriousness of the offense. Unduly depreciate the seriousness of the offense. I want to take into consideration your age, 24, you're very young. You have a lot of life ahead of you. You are realizing you have substance abuse issues. You want to make a change. You've found the Lord. You found God. Those are all commendable things. And the fact that you're so young and you are so malleable and you're so able to be formed. That happens a lot when people are incarcerated. They find God. I hope God stays with you, because God will give you strength. I have conflicting arguments from the Department of Corrections and from the attorneys in front of me. Because the Department of Corrections believes that you are a high risk to committing another offense like this. Especially because of your young age and your intoxicating choices, and because this isn't the first incident. This is the second charged incident. It could have been the second convicted incident, but for the fact of the global offer and, you know, the magic of those agreements. And there are things that I don't get to know about these cases. I don't get to know because I don't get the discovery. I don't get to see all of the information that's contained in the cases until it either goes to trial or there's some motion and I get some glimpse of the evidence, or I get this PSI that has some of the additional information that gives me more, because it's supposed to help and it's supposed to guide with sentencing. And there's evidence and information that there was bruising on the victim's arms, neck, and face. And she experienced severe psychological distress, fearing for her life. And then you knew that she had blocked you from her telephone when you were calling her 100 times. And so you purposely used the *069 to get around it so she would answer. So you can make contact with her. So then she didn't know who she could even answer on the telephone. And if the victim was not able to flee her home that night and get help from the neighbors, it could have been far more serious. We could have been here for something else, something far worse than where we are here today. And I know you're saying all of these wonderful things right now, but you've been incarcerated for 8 months. And I don't know why the victim isn't present in court, and I'm not going to speculate. I only know what she said to the police and what's in the criminal complaint. You have a lot of people here supporting you. A lot of people here. A lot of people believe you can change. Mr. Jones, only you know if you can change, because only you can change you. I'm not following any of the recommendations. I believe they're all way off, way off. This is not merely a probation case. This is not an upfront prison case, because again, you at least deserve an opportunity to show that you're willing to try and make a change. Because if you don't, you're sitting a long time in prison, and you will. As to count 3, suffocation and strangulation, an H felony, sentencing you to 3 years of incarceration with 3 years of extended supervision. Count 6, false imprisonment, I'm sentencing you to 3 years of incarceration, 3 years of extended supervision. Concurrent to count 3. Count 7, stalking, I'm sentencing you to 1.5 years of initial incarceration and 2 years of extended supervision, consecutive to both count 6 and count 3. Those will be imposed and stayed. So you're going to get your chance, Mr. Jones. You're going to get your chance to redeem yourself. You're going to get your chance to show the community and to show the world. But if you don't, you're going to have a lot of time to sit in prison. You are not eligible for the challenge incarceration program, nor are you eligible for the substance abuse program, because this is very serious. So you will sit a long time in prison if you're revoked with no early release. And 8 months serving your last sentence, that's not enough. That's your time for your last sentence. I was going to do a full year. I think it deserves a full year. But I'm going to sentence you to 6 months additional conditional jail. At the minimum, the severity of the offense requires that at the minimum. With regards to fines and fees, $443 for count 3. Excuse me, $518 for count 3, $518 for count 6, $250 for count 7. The court orders that all restitution, surcharges, court costs, and fines are to be collected as a percentage determined by the Department of Corrections to be reasonable while you are in state prison or as a condition of extended supervision if you are revoked. I'm going to order with regards to the OWI 45 days of jail time consecutive to 24 CF 170. $1,844 in fines and fees, OWI assessment, 12-month revocation of your driver's license, 12 months ignition interlock device. Now, as it relates to conditions of probation, absolute sobriety, no use or possession of any illegal drugs, substances, or paraphernalia. Mental health assessment. And to include therapy. That 24-week domestic violence course. What is the name of that course?
A moment, Your Honor, I'll find it.
You must maintain gainful employment or higher education.
The name, Your Honor, is the Domestic Abuse Project in Minneapolis. I don't know if they have any, I think they do have an age restriction of 24 years. So if he's 25 at the time of release, would the court be amenable to a similar program?
As long as it's as lengthy, it's a lengthy program. I'm not going to accept a 4-hour program.
Yes, Your Honor.
Mr. Jones, I believe you were given a gift here today, a gift that perhaps your victim was not able to be given. So you better make the best of it and you better change your life. It can be done. Ms. Rockwell, what am I missing?
Your Honor, did you order credit yet? And
Sure did.
I missed the total period of probation supervision.
Oh, yes, I didn't say that. 5 years of probation.
Nothing else. Thank you.
Mr. Pollack.
Your Honor, I think just post-conviction rights, but I will certainly go through those with Mr. Jones.
Oh, yes, you have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. This is a felony. No use or possession of a firearm for life, no voting in any election until your civil rights are restored. I believe that does cover it.
I guess for the record, Your Honor, I will hand this to this statement to the clerk prior to leaving.
All right, thank you. Then we are adjourned.
All right.
Thank you, Your Honor.